These pronouncements were that we abandoned harsh interrogation techniques which were loosely characterized as torture, and we closed the detention facility at Guantanamo within a year. What's followed has seemed in many instances to be a system in which policy is fashioned to fit antecedent rhetoric, rather than being thought out in advance with arguments then formulated in support of it. With respect to interrogations carried on in the past, because of the at least implicit suggestion of the prior administration had sanctioned torture, the Department of Justice pressed the argument successfully that previously classified memorandum that described the limits of coercive questioning that trained CIA personnel could engage in could be revealed, along with the legal reasoning underlying how those limits were set, should be disclosed, with the result that our enemies are now to be made aware, or are now aware, of precisely the legal and factual limits of how they can be treated if captured, and to train accordingly, as they did before, using the Army Field Manual, which described less coercive techniques that can be used by soldiers in the field and were generally available on the internet. When he was a candidate, the president quoted as saying that it would be absurd to contemplate that brand of warnings to those captured on the battlefield would be given. But the armed forces have been directed to provide such warnings to those captured on the battlefield in Afghanistan. In addition, cases involving claims that CIA personnel acted unlawfully in the course of interrogating prisoners, which were reviewed by career prosecutors in the Justice Department and found insufficient to justify prosecution, except for one case against a contractor that was in fact prosecuted, and the subjects of those investigations were so notified at the time, are now being reviewed again, even though the determinations in those cases were fact-specific. There is no claim that new facts have been developed, and from all reports, the Attorney General who directed that second review take place did not himself read the prosecutor's memorandum that were drafted after the first review, and that explained why the decision not to prosecute was made. And of course, there's been this morning's disclosure that the government intends to bring to the United States several defendants charged with planning and participating in the September 11, 2001 attack, the trial in the U.S. District Court of New York, including the self-proclaimed mastermind of that attack, Khalid Sheikh Mohammed, as well as the principal organizer of the operation, Ramzi bin al-Sheikh. In addition, as I said, another detainee, Mukasey, and others associated with him, at least 3 or 4 others, all actually brought here and tried military force. You may recall that President Bush attempted by executive order to authorize military commissions to try these and other terrorists, and the Supreme Court said he could not do so absent congressional authorization. So Congress passed the Military Commissions Act to provide that authorization. Thus, the military commissions are fully authorized by law. And indeed, the trials would have already begun. You may recall that Khalid Sheikh Mohammed and others attempted to plead guilty and to achieve their martyr's reward during one of their appearances before that military tribunal that was supposed to have begun the trial. But now that procedure is to be short-circuited. Actually, long-circuited would be more accurate, so that they can be brought to this country and tried in a civilian court. We should all be aware that those cases which were scheduled already to be done will now have to start from scratch with the filing of indictments, customary motions addressed to them, and the like. Whether Khalid Sheikh Mohammed will duplicate the demand here that he be permitted to plead guilty to what he's already boasted on several occasions that he did, including on Al Jazeera and on a letter to his wife. Of course, I don't know whether he will or not. But if not, of course, he can avail himself of the full array of procedural steps, including discovery and public presentation of evidence that can turn a criminal proceeding into both a cornucopia of information for those still at large and a circus for those in custody. I would remind you that the Mukasey case, in which the defendant, the so-called 20th hijack, in which the defendant pleaded guilty, took about a year in the trial phase and 4 years from beginning to end, with the defendant acting out and using the courtroom as a forum for his views, and that again was the case in which he pleaded guilty. The tribunal and the facility at Guantanamo were put together with the explicit purpose of handling trials involving classified information and the presentation of evidence at that time in controlled circumstances, along with rules of evidence that have as a touchstone for admissibility whether the evidence is reliable and relevant, not whether it conforms to all the requirements of the federal rules of evidence. You should recall that, unlike the case of a man named Akman Galani, who was recently brought here from Guantanamo to stand trial in the embassy bombings case, the cases against these defendants, whose arrival here was announced today, were not investigated, nor was evidence gathered on the assumption that they would be presented in a federal court with evidence and witnesses secured in the manner that they have to be secured in order for presentation in a federal court. That's only a hint of the difficulties presented by this step, without even touching on the security issues that can be raised by trying to confine and try prisoners who present risks of the sort presented by prisoners like this, including security for the courthouses and jails involved, security for the judge and jurors involved, and the like. This step appears to have resulted simply from a commitment to close Guantanamo within a year, because regardless of the reality on the ground, it has to pour in it, along with the desire to exceed what the law requires in order to show the world that we can do not only what the law requires, but more. At a military trial at Guantanamo, a facility that I have visited, and that is actually less harsh than most medium security facilities in this country, forget maximum security facilities. That such a trial might actually be seen by the American public and the rest of the world as both fair and successful appears not to have occurred to anyone in authority. In a book that I've recommended in the past, and will recommend again, called The Terror Presidents, Jack Goldsmith, who served in the Office of Legal Counsel, describes what he calls cycles of aggression and timidity that have beset the intelligence community, beginning with Watergate, followed by the returns, followed by a pullback and the result of criticism of excessive timidity during the Cold War, followed by Iran-Contra, followed by another period of pullback and demoralization, followed by criticism after the September 11, 2001 attack of a failure to be sufficiently aggressive, a failure to both collect and connect the proverbial dots. We now appear to be in a cycle where the pendulum appears to have swung yet again in the other direction, with a willingness to disclose the limits of how we gather intelligence and to risk that defendants will turn legal processes into a source of intelligence for themselves and to a forum for expressing their views. If I thought that I or my family or my fellow citizens had 3 lives to live, I suppose I could be persuaded that we should live one of them as a social experiment to see whether the result here is one that we want to live with. But I don't, and they don't, and you don't. It would take a whole lot more prejudice than I have available to be optimistic about the outcome of this latest experiment. And with that, I'd be happy to take questions. There are 2 microphones, one near the front, one in the back. And I was urged as a due process matter to alternate these microphones. Carrying that concept